Hello everyone, my name is Dhanashree Chougule and I'll be discussing the topic Remedies for Breach of Contract. So in this topic, we'll be covering the following concepts: meaning of contract, breach of contract, remedies for breach of contract. Before getting into the topic, let us try to understand the meaning of contract and what do we mean by breach of contract. Meaning of contract. Section 2H of the Indian Contract Act 1872 states that an agreement enforceable by law is contract. A contract is a legally binding agreement that is enforced by the full weight of the court. In the event that either party to the contractual agreement fails to perform according to the terms of the contract, the other party may take legal action. In simple words, a contract is a promise or a set of promises for the breach of which the law gives a remedy or the performance of which the law in some way recognizes as a duty. A shorthand definition is a contract is a legally enforceable promise. A party who fails to perform is referred to as the breaching party. A civil lawsuit for breach of contract may be filed to obtain a remedy for the breach. The next, breach of contract. Breach of contract is a legal cause of action and type of civil wrong in which a binding agreement or bargain for exchange is not honored by one or more of the parties to the contract by non-performance with the other party's performance. So, as explained in the meaning, a business contract creates certain obligations that are to be fulfilled by the parties who enter into the agreement, which means in case if one party fails to fulfill any of its contractual obligations, it is known as a breach of contract. Breach occurs when a party to a contract fails to fulfill its obligation, whether partially or wholly, as described in the contract, or communicates an intent to fail the obligation or otherwise appears not to be able to perform its obligations under the contract where there is a breach of contract. Now let us understand remedies for breach of contract. It is rightly said, where there is a right, there is a remedy. A contract gives rise to correlative rights and obligations. A right accruing to a party under a contract would be of no value if there were no remedy to enforce that right in a law court in the event of its infringement or breach of contract. A remedy is the means given by the law for the enforcement of a right. Which means when one party breaches a contract, the other party may ask a court to provide a remedy for the breach. The court may order the breaching party to pay money to the non-breaching party. So these are various types of remedies available for breach of contract, which are suit for rescission, suit for damages, suit for quantum merit, suit for specific performance, suit for injunction. So let us try to understand one by one. First one is suit for rescission, where consent to an agreement is caused by fraud or mistake or misrepresentation. The agreement is a contract voidable at the option of the party whose consent was so caused. In other words, term rescission refers to the cancellation of contract. In such cases, if one party has broken his contractual relations, the other party may treat the breach as discharge and refuse to perform his part of performance. On the other hand, where both the parties to an agreement are under a mistake of fact essential to the agreement is void. Thus, in case of rescission of contract, the aggrieved or injured party is discharged from all his obligations of the contract. So the next is suit for damages. Section 73 to 75 of the Indian Contract Act 1872 defined remedy by way of damages as the entitlement of the suffering party to recover compensation for losses suffered due to non-performance of the contract. In the event of breach of contract, the aggrieved party, beside cancelling the contract, can claim for damages. The fundamental basis of awarding damages is compensation of the monetary loss which naturally flows from the breach. The damages can be of following types. Ordinary damages, which means ordinary damages are the damages which fairly and reasonably be considered as arising naturally and directly in the usual course of things. Special damages. A party to a contract might receive a notice of special circumstances affecting the contract. In such cases, if he breaches the contract, then he is liable for the ordinary damage plus the special damages. Exemplary damages. There are two scenarios for awarding exemplary damages: breach of a promise to marry because it causes injury to his or her feelings, wrongful dishonor or check by a banker because it causes loss of reputation. Nominal damages. If a party to a contract files a suit for losses but proves that while there has been a breach of contract, he has not suffered any real losses, then compensation for nominal damages is awarded. This is done to establish the right to a degree of a breach of contract. Damages caused by delay. In case where goods are being transported by a courier and he delays the delivery of goods, causing them to decline, the affected party can file a suit for a damages for the delay. The next remedy is suit for quantum merit. The phrase quantum merit means as much as earned. A right to sue on a quantum merit arises where a contract partly performed by one party has become discharged by the breach of contract by the other party. The right is founded not on the original contract which is discharged or is void, but on an implied promise by the other party to pay for what has been done. This concept may be used as an equitable remedy in a civil lawsuit, often where the transaction for goods or services was done without a written contract specifying the amount due. Next is suit for specific performance. In certain cases of breach of a contract, damages are not adequate remedy. The court may in such cases direct the party in breach to carry out his promise according to the terms of the party not in breach. This is a direction by the court for specific performance of the contract act, the suit of the party not in breach. This clause provides that the person seeking specific performance must prove that he has performed or has been ready and willing to perform the essential terms of the contract which are to be performed by him. So the last remedy is suit for injunction. Where a party is in breach of a negative term of a contract, the court may, by issuing an order, restrain him from doing something which he promised not to do. Such an order of court is known as injunction. An order of the court which prohibits a person to do a particular act. An injunction may be issued for and against individuals, public bodies, or even state. A suit for injunction is a very common and effective remedy against any mischief played by a third party. All the civil courts are empowered to issue injunctions. Thank you.